Now we have with us as our next speaker, Mr. Tahar Boumedra, former Chief of the Human Rights Office of UNAMI and Chair of JVMI.
JVMI was launched in September 2016, seeking justice for the victims of the 1988 massacre in Iran. Its board includes prominent personalities such as Lord Alton of Liverpool, Sir Geoffrey Bindman, QC, William Bourdon, Professor Bill Bowring, Christy Bremlou QC, Malcolm Fowler, Dr. Juan Garce, and Ramayad.
On 24th of May, 1989, the United Nations Economic and Social Council adopted a resolution 1989/65, recommending the principles on the effective prevention and investigation of extra-legal, arbitrary, and summary executions. Principle 9 of these principles reads, "There shall be thorough, prompt, and impartial investigation of all suspect cases of extra, arbitrary, and summary executions, including cases where complaints by relatives or other reliable reports suggest unnatural death." This resolution coincidentally came a year after the 1988 massacre in Iranian prisons, when gross and reliably attested violations of human rights in the Islamic Republic of Iran were brought to the attention of the Special Representative of the United Nations Commission on Human Rights by families of the victims and NGOs. The United Nations Special Representative, Professor Rinaldo Galindo Paul, whose mandates covered the period extending from 1986 to 1996, reported that extra-legal, summary or arbitrary executions of thousands of political prisoners held in jail across Iran had taken place before, during, and after the 1988, the summer of 1988. All the persons appearing before the special representatives alleged that they had been arrested without any warrant, mostly by groups of revolutionary guards who had detained them in their homes or on the street. In some cases, persons were arrested while accompanied by family members, including babies or children. Most of the persons described the conditions of their arrest as brutal, accompanied by beating and other forms of ill treatment. In most of the cases, no explanation was given to the detainee as to the reason for his/her detention. In other cases, explanations were given in a vague way. Some of the persons spent months or sometimes years in prison without any formal accusations being brought against them. Allegations were also made of long periods of incommunicado detention and of denial of family visits. The report underlined that in the course of the informal hearings, the special representative reached the moral conviction that the persons appearing before him referred to facts that certainly happened to them, and that their declarations were not the product of feverish imagination or of mere fabrication guided by political or religious motivation. Most of the executed were reported to be members of the People's Mujahideen organization in the implementation of the cleansing policy. The mass killing have been carried out on the basis of a fatwa by the regime's then Supreme Leader Ayatollah Khomeini, stating, "In the name of God, the compassionate and the merciful, it is declared that those who are in prison throughout the country, who remain steadfast in their support of the munafiqeen, are considered to be muharib, waging war on God, and are condemned to execution." When asked who could be executed and who should be spared, Khomeini wrote to his son, "Don't waste time, kill them all." Some members of the Death Committee are currently occupying important positions in the hierarchy of the Iranian administration of justice. On August the 9th, 2016, an audio recording was made public for the first time of the then Khomeini's designated successor, Grand Ayatollah Hussein Ali Montazeri. In his recorded statement, a few days after the execution started, Montazeri is heard qualifying them as the most heinous crimes committed in the Islamic Republic of Iran. In the same medium, the alleged perpetrators are heard acknowledging their role in that mass killing in implementation of orders coming from high above. It is further revealed in the audio tape that officials of the Islamic Republic of Iran, including Khomeini's son, have been pursuing the plan to execute all prisoners, particularly those affiliated with the PMI. Evidence, including information provided by the survivors, indicate that the preparation for the massacre started in the prisons simultaneously with the acceptance of the ceasefire in the war with Iraq. Following the revelations of the Grand Ayatollah Montazeri, Iranian officials started acknowledging in the 1988 massacre. In the absence of any official independent inquiry to the mass extra-legal killings and the inhuman or degrading treatment or punishment of prisoners, and given that the Iranian government had proved to be unwilling to cooperate with the UN special procedures on this matter, justice for 1988 massacre of the political prisoners in Iran, in short JVMI, association based in London, had probed into a large amount of data emanating from various sources, including statements of officials of the Iranian government, and published 2 reports on the 1988 massacre, shedding light on what happened and identifying the suspect perpetrators. The 2 JVMI reports of 2016 and 2017 were published and submitted to the United Nations competent organs, calling for the establishment of a UN Commission of Inquiry to investigate the alleged massacre. It should be underlined that the persecution of political prisoners in Iran on the ground of their political, religious, and ethnic belongings is an ongoing crime that must stop, and the perpetrators must be brought to justice. Today, in the absence of accountability, the Iranian regime is getting emboldened by persecuting peaceful demonstrators who request that the public funds be spent on the well-being of the people of Iran, rather than on exporting the Islamic revolution. Political executions, including juvenile, continues to date in Iran. Iran has the highest rate of executions per capita in the world. It continues to be the very few countries among the very few countries that still use public hanging. So after all that, and after 32 years since the 1988 massacre of political prisoners, it is clear that the Iranian officials are unwilling to act on the calls of the UN to investigate and reveal the truth. It is also clear that the United Nations human rights agencies are unable or unwilling to set up an independent commission of inquiry without the consent of the Iranian authorities. The UN agencies prefer to use the soft policy and leave the door ajar for public or possible dialogue with the Iranian authorities. So what are, in the circumstances, the other avenues left to the families of the victims? In this context, I suggest three possible avenues. The first avenue is to be considered. The first avenue to be considered is that of the universal jurisdiction. As most Iranian suspects in the commission of crimes against humanity are already listed for terrorist offenses and for crimes under international law by the EU member states, the United States of America, Canada, and other countries. It is therefore possible for a national court of these states to accept jurisdiction over an act categorized as a crime against humanity. Although political considerations are generally taken into account in accepting or rejecting such a jurisdiction, it is possible. It is the responsibility and the raison d'etre of the human rights defenders to insist and to facilitate prosecutions and make them happen by searching, documenting the evidence and placing it at the disposal of the jurisdiction willing to prosecute. The second avenue is for the human rights defenders to facilitate the conditions for the chief prosecutor of the ICC, the International Criminal Court, to initiate on his own initiative, after seeking permission of the concerned chamber of the ICC, to undertake a preliminary investigation of the most serious crimes. The third avenue is that of referral. The referral of the case by the United Nations Security Council to the ICC to investigate and prosecute. The referral solution is subject to the acquiescence of all permanent members of the Security Council. A veto of a permanent member will stop such a referral and will prevent the involvement of the ICC. However, the acquiescence of the permanent members of Security Council is not always impossible. The referral of General Hassan al-Bashir of Sudan was initiated by a group of NGOs and was not vetoed, thanks to the hard work of the perseverance of the human rights defenders. Thank you for your attention and for listening to me.